Good morning and welcome to Rising. We have a very eventful show today. Number of protests happening across college campuses all over the country. We'll be covering a lot of those, including with guests, students who have been on the ground at those protests. But first, we've got some breaking news. Why don't you take it away, Briahna?
Yeah, in a stunning reversal this morning, New York State's highest court overturned the conviction of the former movie producer Harvey Weinstein, who in 2020 was found guilty of 2 felony sex crimes. The case against the once powerful producer served as the foundational case for the Me Too movement, prompting women from Hollywood and then many other industries to come forward to discuss cases of sexual harassment, abuse, and assault in the workplace and beyond. It was a movement that shook the very core of the workplace and the workplace dynamics. The reopening of this case opens a painful chapter for some people who were involved in that movement.
Well, the appeals court said it based its decision on that prosecutors were allowed to call witnesses who said Weinstein had assaulted them, but then were not part of the actual charges against him. The decision said that under our system of justice, the accused has a right to be held to account only for the crime charged, and thus allegations of prior acts may not be admitted against them. It was October 2017 when investigations by the New York Times and the New Yorker broke open the allegations against Weinstein. One of the original reporters on the case, New York Times' Jodi Kantor, said the criminal case against him was always somewhat fragile outside of the courtroom. Now, many believe the evidence of Weinstein's conduct was, in fact, overwhelming, with many big-name Hollywood stars like Ashley Judd and others coming forward.
Yes.
So
what's important to know right off the bat is that this does not mean that Harvey Weinstein is out of jail.
No.
He was also convicted in a California case. So this does mean he will be transferred from New York custody and prison to California prison. However, this is still remarkable. Sorry, I didn't mean to interrupt.
That's exactly what I was going to point out. It's worth recalling that a similar thing happened with Bill Cosby, found convicted for sexual crimes, and then that conviction overturned, vacated, I believed, for not exactly the same reasons, but for procedural issues with the case.
Well, there's some overlap here, and both cases, as I understand it, involve the question of propensity evidence. So you're not allowed to admit evidence that shows that basically because of some other uncharged crime, this person did something else bad, so this person broke the law in some other instance, maybe proven, maybe unproven. You can't bring that evidence in to show that they're just criminal in nature. They have this character flaw, and therefore they're likely to have committed this crime too. You have to actually bring evidence that shows that they've done the thing that they're actually charged with in this case. There are some exceptions to that rule.
Right.
Largely, you can kind of think of it as if their behavior shows a pattern of behavior. Are they a serial murderer that always leaves a yellow rose at a crime? Well, the fact that they left a yellow rose was left at this crime doesn't speak to the person's character, that they have a criminal propensity. It speaks to the fact that they have a pattern of behavior, which is also being reflected in this instance. So this was a 4-3 decision. It was a really close one, and the folks writing for the dissent were saying, yes, we have an exception to what this New York rule, the Molyneux rule, which is basically this propensity evidence rule, that says, are there factors which would suggest that this evidence is being brought in to say that this is something that this is a pattern of behavior, basically, of this person? Is this evidence going to an issue other than to prove that this person is of bad character, that this is a person who does sexual assaults and rape? And there's a difference in opinion as to where the evidence falls.
Right. Derek Thompson of The Atlantic tweeted this, and I think this is a good question. I responded basically, I think the answer to this is it depends, and this works unless the defendant files an appeal on this basis. He asks, if you're being charged with robbing a CVS and the prosecution calls 2 other CVS owners at 2 different CVSs and say, this guy robbed me, can you do that? And the answer is maybe. I mean, frankly, the answer is maybe.
That's right. And in this case, and in sexual assault cases in particular, part of the issue was that a lot of the witnesses were time barred from actually bringing claims on their own. So there did, just putting the law aside for a second, there did seem to be some sort of asymmetry or a sort of hole that was in the middle of this case, where there were all of these people that were able to give kind of public testimony and talk to reporters and participate in the Roden Faro and the reporting of it all, who simply had no avenue to litigate their claims because they were time barred. The statute of limitations had lapsed. But they could speak outside of being able to actually press their own charges, potentially in the context of these other cases, to their experiences with Harvey Weinstein to establish a pattern of behavior. And in sexual assault cases, oftentimes there is this issue where the jury's conception of how people act in the context of being sexually assaulted can often prejudice the claimant, be prejudicial against the
Why
victim.
didn't you resist?
Why didn't
blah,
you
blah,
resist?
blah.
Why did you still work with this person?
Right.
And so the other people coming in to testify about how Hollywood works, the kind of favors and the quid pro quo that they experience in dealing with Harvey Weinstein was supposed to dispel some of that bias. And that is why the evidence was admitted in the first instance. But obviously there can be difference of opinion about that. And now the majority is saying that that evidence allowed a cross-examination of Weinstein on some of these facts that went to his guilt in these other cases, and that ultimately the balance of what was probative versus prejudicial was too prejudicial and unfair to Weinstein.
It's a reminder that the court of public opinion is not the same thing as an actual court. There are very important fundamental bedrock due process principles, the right to cross-examine witnesses, the right to have an attorney, the presumption of innocence, the statute of limitations, all of that applies to a court hearing that doesn't apply to the public opinion. You can write an article, you can interview people who say this happened and this person is a monster because of it, and that can be persuasive to the people, and the people can say this person should no longer work in Hollywood or anywhere else, and their conduct is abominable and is unacceptable, and we have to have industry-changing practices, and still have that all not be enough to necessarily land a conviction. Now, of course, he was convicted elsewhere, and they can retry him. This is just saying that the decision was based on a procedural error, and so he can be retried. Now, whether they want to do that, I don't know, given that he is staying in prison for culpability in a different state. They might not want to even bother with that.
Yeah.
It might not be a good use of public resources, frankly. But this is just saying that the trial would have to happen again.
Yeah, absolutely. And I mean, we were having a similar kind of conversation recently as we were discussing the Quiet on Set documentary, which talked about the influence of a particular director who worked on with children's programming. And that was, scandalous expose, largely because, Dan Schneider, especially because there had been repeated instances on set, I think 2 within a year or maybe even months of each other, of 2 different individuals who were charged with sexual, I think one was the possession of child pornography, and another actually sexually assaulting pretty violently one of the child actors on set. And despite all of this, there were no institutional changes that could have protected children going forward. And that, I think, is the biggest and most damning aspect of this. So when we're talking about a culture that allows Dan Schneider and to continue to oversee these sets, to participate personally in some of what people describe as abusive behavior, requesting that women writers give him massages, writing these scripts that were so suggestive and making the child actors, people, you're watching video clips of Ariana Grande, people who are very famous and powerful seeming now, being asked to participate in skits, which are clearly for an adult eye. It's horrifying to watch, but the bigger question is how is he able to do that kind of out loud and in public and it not be pushed back
Harvey
against?
Weinstein doing it in a way that everyone knew about, and people joked about it. Family Guy joked about it. They joked about it at award shows, and everyone kind of laughed along.
So that being the case, that is why this kind of evidence, many people think, should come in, because it shows exactly how this kind of thing works in a sector that many people, especially at the time of this trial, weren't that familiar with. Maybe now going forward, because of Weinstein, your average juror is going to have a sense of how the casting couch works and how there can be these cultures of secrecy and privacy that protect people. And maybe going forward, with these witnesses wouldn't have been necessary in the first place, and this conviction would not have been overturned. But it's a difficult thing to kind of cast judgment on in hindsight.
Yeah, indeed. Well, we will continue to monitor that, and we have much more rising coming up next.